Hello, this is Matt on the Moon Lambo channel. Here's a headline from the Crypto Basic. In latest update, SEC opposes Ripple request to conceal information relating to XRP sales. And so the SEC last night filed a response to Ripple's, the motion to seal. And I'll give you all the latest on that. And interestingly, one analyst, upon seeing what's going down here, highlighted what he believes is the one thing stopping Judge Torres from making a final ruling in the remedies phase of the SEC v. Ripple lawsuit. So we'll break this all down for you. It is the latest. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, before reading this article, I just want to say, think about how many times in the Ripple lawsuit the SEC sought to hide information from the public. I mean, we quickly lost count, right? Including that information which pertains to Bill Hinman, for example, and who he worked with and the conclusions that he came to regarding ETH. How did he decide that ETH itself is not a security? Think about all the stuff about him, even just him, that the SEC sought to hide. Yet here, the SEC is arguing that it's in the public's best interest to know Ripple's private sales figures. It's just so damn hypocritical, man. It's just so hypocritical. Anyway, piece reads as follows. U.S. SEC opposes in part Ripple's request to steal information relating to its confidential business information, including discounts offered to institutional buyers of XRP. Now, I just want to pause to note here. The judge knows this information either way. So, as it pertains to ultimately what happens in the remedies phase of this lawsuit, SEC v. Ripple, whatever's going to happen is going to happen. The SEC is saying we, the public, should know Ripple's private business goings-on. And I don't think that they genuinely believe that's necessarily what's right or should happen. I'm just noting that that's what they're arguing because they're vicious, terrible excuses of human debris. They're just disgusting people. Piece continues. According to an update shared by seasoned defense lawyer James K. Filan, the U.S. SEC has filed its opposition to Ripple's omnibus sealing motion. The SEC's opposition comes a week after Ripple filed an omnibus motion to seal certain exhibits regarding its confidential business details, especially those relating to its XRP sales. In particular, Ripple asked the court to seal its financial statements, discounts offered to institutional buyers of XRP, and other confidential business information. In the SEC's opposition, the regulatory agency noted that it partially opposes Ripple's omnibus sealing motion. The SEC argued that Ripple failed to overcome the strong presumption that court filings should be made public by seeking to redact highly relevant information to the parties' remedies-related briefs. Quote, and this is from the SEC, Ripple invites the public to form opinions about the merits of the SEC's position. Thus, it cannot simultaneously hide from the evidence on which that position is based, end quote. According to the SEC, some of Ripple's sealing requests would conceal pertinent information crucial to the court's determination of the remedies litigation from the public. While the SEC did not completely challenge Ripple's request to seal its recent financial statements, the regulator asked the court to make public financial figures and terms used to calculate and justify remedies requests. Quote, the general deterrence of a civil penalty rests on the public understanding of the facts supporting the penalty amount. End quote. Well, I'll tell you what the public understands right now is that literally none of Ripple's customers or anybody that they ever sold XRP to, none of them have been harmed financially or otherwise. None. Not one single incident. And the SEC isn't alleging that. They just want the penalties anyway. Because, and basically, you know what the argument is in a nutshell? The SEC is arguing, basically, and these are my words, but that Ripple is picking and choosing various rates, so basically favoritism for some clients over others, because individual deals were penned. But if you're an institution and you know that you're negotiating a deal, wouldn't you assume that other institutions are probably doing the same thing, and maybe some of them negotiate a little bit better of a deal? Or maybe the discounts for XRP offered are different because maybe you're buying different quantities? Maybe that's a factor? How about that? Duh! Anyway, piece continues. Furthermore, the SEC objected to Ripple's requests to seal the financial terms regarding the discounts offered to XRP institutional buyers. The regulator argued that Ripple made the request to hide how it offered XRP at discriminatory prices. And there you go, discriminatory prices. The SEC referenced Ripple's argument, which claims that if the discount's financial terms become public, it could damage the company's negotiating position with counterparties. Quote, Ripple has not shown how old discounts would cause substantial harm, especially where it claims it has not offered discounts in years, end quote. Yeah, so they're not offering the discounts anymore. How is any of this relevant anyway, though? Like, why do we, the public, need to know any of this? I mean, I can understand any of you out there being legitimately curious, but, you know, I still think it's none of our damn business. Now, if it's public, yeah, we'll talk about it because this damage is done at that point. Everybody's going to know about it. But I don't see how this makes logical sense. To what end does this actually help anyone other than satisfying curiosity? I don't see how it does. Piece continues. The SEC specifically objected to the redaction of certain Ripple's financial statements, such as the company's current assets amount, revenue from non-XRP sales, and post-complaint ODL-related sales of XRP. It contended that these data points are relevant to the court's decision regarding Ripple's penalty and injunctive relief. The court will issue a decision regarding which exhibit and document requires sealing. This decision could be issued at any time, and the parties will be required to publicly file redacted versions of the documents within 14 days after the ruling. Meanwhile, popular XRP community figure Ashley Prosper speculated that the only thing, and that's a quote, only thing stopping Judge Torres from issuing the final judgment is the decision about whether Andrea Fox, a top-level SEC accountant, is an expert or summary witness. Prosper asserts that this issue could lead to more delays in the case. And so you guys may recall that whole issue. Basically, I mean, kind of in a nutshell, Ripple's arguing with this particular individual, Andrea Fox, the SEC, rather than going through what should have happened during the discovery process, having Andrea Fox be an actual expert witness, they're pretending it's just a regular run-of-the-mill accountant. Ripple's arguing that there are things being communicated here that go beyond that and basically make her the equivalent of an expert witness. Now, if that's true, then the SEC has done something sneaky here. But Ashley Prosper here is saying this is pretty much the last thing that we're waiting on after this. There's no reason not to have a ruling much sooner than later. Now, here's a post from attorney Bill Morgan of the XRP community. He highlighted this particular screen grab and wrote the following. The SEC clarifies that none of the sales to institutions with discounts were ODL contracts. The SEC would have reviewed the ODL contracts and observed that they do not have discounts or the features referred to in the summary judgment that made institutional buyer contracts to be investment contracts, according to Judge Torres. The ODL contracts require ODL customers to purchase XRP at market prices and to use the XRP in ODL transactions and agree not to hold them as investments. It remains a mystery why Judge Torres lumped them in with the other contracts with institutions. I bet the SEC knows the ODL contracts are not investment contracts. Yeah, of course. Now, I'm sure that the SEC knows that. They're going to argue otherwise because they just want to win and they're scumbags. They're just a bunch of asshat pricks. That's a matter-of-fact statement. That's not even an opinion. That's scientific fact, damn it. But it is weird. Judge Torres, I don't understand this part. I mean, that's the worst part of her ruling, arguably. I mean, we got what we wanted, though. XRP itself declared non-security. But Judge Torres, obviously she's aware that these transactions, the XRP, it's not being held. It's clearly not an investment. It's XRP being used literally for ODL as a bridge currency. Why would that then get lumped in with any sort of other investments made from Ripple customers, like on an institutional level? That doesn't make a damn bit of sense, but that's pretty much where we're at right now. So Bill Morgan, as usual, is correct on this stuff, and he's been talking about this a fair bit lately, and he's right. It doesn't make any damn sense. And I literally don't understand. I mean, I remember breaking down the final decision when it came out in July of last year. It doesn't make sense. I don't see the rationale for that. How could you say the Howey test applies to that? Is what it is, though. We got what we really wanted. We as XRP holders, though, XRP itself not a security, so I won't bitch too much, but a little bit. I'll bitch a little bit about it. So anyway, that's the latest. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.